So welcome to Legacy Conversations. This week or tonight, we'll be talking about estate planning basics. And if you've seen the flyer, we're going to cover wills, power of attorney, advanced medical directives, trust. But before we get into that, if I could just, if you all could put in the chat just who you are or where you're specifically where you all are listening from or attending from, just to get an idea of where everyone is located. I see Charlotte, I see Virginia. Okay, nice, nice. All right. Well, welcome, and like I said, thank you. And I also want to just first start off by saying congratulations for making the choice to join and learn about estate planning and being proactive in this process. So just a few things, kind of the goals of tonight's session is to cover just what is estate planning and why is it necessary, the primary components of an estate plan, what happens when there is no plan, understanding what probate is and how it works, and then also just assets not covered by a will. I'm a person who I like examples and being able to relate things to real life. So I will also be including some examples as we go through. This is for educational purposes, and the goal is for you all to learn as much as possible. However, I do ask that you hold your questions until the end, just because I want to try to make sure we get through everything. And then I'll be happy to answer questions towards the end. So just a few things about me. My name is Latavia Alexander. I love purple. I have been licensed for 10 years. I'm currently licensed in North Carolina, DC, and Maryland. So for the person from Virginia, my apologies. This is I would not necessarily be able to directly assist, but I do hope that the information is helpful. One of my guilty pleasures for the last couple of years has been watching Married at First Sight. I am a proud member of Zeta Phi Beta Sorority Incorporated, and love to laugh. And so like I said, thank you all for being here this evening and joining in this conversation with me. So I call it Legacy Conversations. I think we hear the word legacy thrown out a lot, but kind of what is it? The legal definition of legacy is a gift by will, especially of money or other personal property, essentially something that's transmitted or received by an ancestor, essentially just passing things down. That's the legal definition of it. I like to say my Latavia definition is essentially it's what you're remembered for, or how people remember you, what you've created, and what you pass on. And so that could be, I think there's components of the legacy. There's that intangible legacy of just, they always say people don't remember you for, what you did, but how you made them feel, things of that nature. And then there's also the tangible piece of, hey, mom and dad spent time building up a portfolio or assets, and they left that to me. So what is estate planning? Estate planning is literally the action of arranging a person's life before their death, or essentially, as I like to say, making a plan. And making a plan, it minimizes the effects of gift or estate tax, generation skipping transfer. I want to put this disclaimer out there up front. I am not a tax attorney, so I will not be getting into the nitty-gritty of the various aspects of tax implications or risk, but it's important to know that that is a component of it. So I used to hear this all the time growing up. If you fail to plan, you plan to fail. So the goal, like I said, of this session is to, one, give you the information and to encourage you to start having the conversation with yourself as well as with your family. So when we're talking about a plan, I like to break it down into two parts. And you'll hear me say legacy planning throughout the evening because that's what I like to call it. So there's what I like to call life documents, and then there's the documents that address things after death. So we're going to start with life documents. And so those are two. There's the advanced medical directive or living will and a power of attorney. So an advanced medical directive it's a document with written instructions for how your healthcare will be handled when you are no longer able to make those decisions yourself. It gives you the ability to appoint a person as your healthcare agent. So if you think of, we're still coming out of this pandemic, I believe we're on the other side of it, but if you think about it, there were people who were temporarily incapacitated, or if something happens to where you're just temporarily or long-term, you are no longer able to make decisions for yourself, you want to make sure you have someone designated who will be able to make those decisions, but make them in a way that honor what you would want if you could make those decisions. So just about every state has a statutory form or version of this form that you can use, or you can, most medical providers have a form that you can use, or you can create it yourself. But essentially the key components of the advanced medical directive are one, designating, acknowledging who you are, designating a healthcare agent, which essentially you could have one person, you could have two people, or you could have a primary and a backup. But you want to make sure that you make it clear who that person is, and then listing out what powers you want to give them. And so that could be, I want them to essentially, if something happens to me, I trust them to make all the decisions, whatever they think is best. You could say, I want them to make decisions, but these are when it comes to specific scenarios, this is how I want you to decide. These are the people that I want you to consult before making a decision. And also you could go as detailed or as far as specifying in certain end stage situations, whether or not you want to be kept on life support, if you want them to, if you hear people say they have a DNR or a do not resuscitate, those are things that you can address in the advanced medical directive. And those are the reason I call that a life document is because regardless of our age, status, something can happen. The unexpected can happen and we never know when. And so you want to make sure that you've taken some time to think about what you would want to happen, how you would want to live your life. If you end up in a vegetative state, would you want to be kept on life support and say, hey, keep me here, keep me ticking for as long as possible? Or, hey, after a certain amount of time, take me off or consult with the doctor. So just those are some examples of what, the power that you have to be able to make decisions for yourself. The second life document that we're going to talk about is a power of attorney. And that could be a durable power of attorney. You may have heard of a power of attorney in the context of real estate or finances, but that is also another document where you provide written consent to another person, giving them the authority to act on your behalf, to conduct business, whether it be your, a business that you have, your day-to-day personal business, finances, real estate, you name it. And with this one as well, you're going to designate a person or people. I encourage people to have at least one person and then a backup, because the risk of having two people is if they are not in agreement, it will delay things happening. But caution, I would say proceed with caution before actually executing a power of attorney, because you are given the person the authority and the right to act as though they were you. So they can open accounts, they can take out credit cards, they can sell property, they can buy property. With depending on where you are, but it gives them a lot of control over your assets while you are still alive. You just may not be able to, once again, have the capacity or ability to do that for yourself. So choose your person wisely, because you don't want to end up granting it to someone and then they abuse it, because depending on where you are in life, you may not be able to revoke it. Now, of course, if you are still of sound mind, you can always revoke it as long as you're living. But if something were to happen where either temporarily or permanently, you no longer had the capacity to enter into a contract, then you would not be able to revoke that yourself. And then that's when people get into litigation and it can get a bit messy. So those are two life documents. So as I mentioned, I like examples. I don't know if anyone has ever heard about Terri Schiavo. This was prior to this case gaining national coverage. I would not say that she was someone who was famous that we would just know of her, but she and her family became very well known because due to some other health conditions, she ended up suffering a cardiac arrest and ended up they determined that she was going to be in a persistent vegetative state and was placed on a feeding tube. And this was in 1990. Now she was married and her parents were alive. It initially happened in 1990. So for about 3 years, her husband and parents were in agreement in terms of the doctors trying all different types of tests or experiments to see if she would ever regain consciousness or any functionality. But after 3 years, it was determined, okay, there is not going to be any progress. And at that point, her husband decided, hey, she would not want to live her life like this. And by the way, she was 26 when this happened. She would not want to live this way. I think he wanted to essentially pull the plug, take her off of life support. But her parents disagreed. They did not believe that, they believed that she could make a recovery and they wanted to keep her alive in the event that something would change and that she would regain consciousness. So because there was nothing in writing specifying what she wanted to have, it ended up going to litigation, and it took a total of 15 years of disputes between her husband and her parents before, and this was them going to courts, and that's when it gained national coverage, of media coverage of just, hey, what's going on here? They spent a lot of years, time, resources in litigation, trying to just essentially to make the decision, do we keep her on life support or do we let her pass? What would she want? And so, like I said, it was a long time, a lot of emotions, a lot of things. And eventually the multiple courts ruled in the favor of the husband. And he was able to take her off life support. But like I said, so this is just an example of the one that just because we're young or you're young, I don't need that, I've got time. We never know what's going to happen. So I always say, if nothing else, get your life documents in place. So that way, if something, if the unexpected or something tragic happens, you have made your requests known, your wishes known. So that will relieve a little bit of the stress related to having to make these decisions for your loved ones, because at least instead of having to speculate and try to figure out, well, I think she would want this, I think he would want that, no, he wouldn't want this, no, he wouldn't want that. It's clear, it's there in black and white. It's been written. And one thing I did not mention before, with the life documents, with the advanced medical directive, as well as the power of attorney, both of them require the person creating it to sign it, and it needs to be witnessed by 2 people. Most states require that the power of attorney is notarized as well. So those were the life documents. Like I said, those cover the what ifs, the unexpected events while we are alive. Now, when we pass, whether we like it or not, to my knowledge, we are all going to die at some point. And so it's just a matter of when and how. So if we do not make a plan, I'm here to let you know that a plan has already been made for you. Every state has what they call intestate succession laws. And what these do is spell out how your assets will be, essentially what happens to your estate when you pass. And most states have tried to think of what the average or reasonable person would do, or who they would want things to go to when they passed away. So the law of intestacy, essentially, like I said, it provides rules for distributing property belonging to people who die without a valid will. And I point out valid because, and I will talk about this a little later, there have been situations where someone created a will or started creating a will, but it was not valid. And so it was treated as though they died intestate. So I mentioned that I'm licensed in Maryland and North Carolina. And so I'm going to provide examples specifically from Maryland and North Carolina of what happens if you were to die without a will or some type of plan in place. So if you have children but no spouse, and specifically in Maryland, the children will inherit everything. If you have a spouse but no children or parents, your spouse gets everything. If you're married and have children and they're minors, your spouse is going to get half of your intestate property, and the children inherit everything else, and they will inherit, if there's 2 children, they will inherit equally. So if we're thinking 100, the spouse would get 50, the children would split the other 50. And then it goes on, if you know there's spouse and descendants, but no children who are minors, and descendants can be grandchildren, it could be siblings or parents. It just depends. And like I said, so it goes through, this is just a snapshot of, because if you think of the financial piece, if there's money or money in a bank, then that would be something that's considered a part of the estate as well. If there's a situation where you are not married, you do not have any children, and your parents are still living, then everything will go to your parents. If your parents are no longer living and you have siblings and no children or grandchildren and your siblings are still alive, then it will be your siblings will inherit everything. Similar for North Carolina, but one key difference with North Carolina is North Carolina specifies monetary amounts. So if you have a spouse and one child or the child's descendants, the spouse receives the first 30,000 worth of personal property. So let's say, for example, you had 50,000 in your bank accounts or of personal property that could include vehicles. Your spouse would get the first 30,000 of that, or whatever is worth 30,000. The remaining would be split evenly between the spouse and the child. Same thing if there's multiple children, like I said, and then if it's spouse and one or more parents, the spouse receives the first 50,000 worth of personal property, and then the remaining is split evenly between the spouse and the parents. Now, what's not mentioned in these charts is that probate or estate administration is a part of any process when someone passes away, but there are court costs and fees and taxes that can easily creep up if you do not have a will. And so there's often more time and money required when there's not a plan. And then there's also the risk that what the state decided for you is not what you actually intended. And this often becomes an issue when there's a situation of blended families or stepchildren, adopted children, or like, hey, I've never legally adopted this person, but they're like my child. So it makes a big difference when you do not have a plan, because granted, yes, hey, if it's me, I'm gone, I don't have to deal with it, but my family, my heirs are left to deal with this. And it oftentimes makes a difficult time that much more challenging and stressful. So I just want to go through a few examples of some people that most are familiar with in terms of these are people that passed without a will. Most recently is Chadwick Boseman, Black Panther. I loved him as an actor and just what I knew of him as a person. And sadly, he died much, earlier than any of us anticipated. I mean, I'm sure that he did, but when he died, he did not have a will. And if you all recall, he died in 2020. It was just last month, actually, that his estate was settled. He and his longtime girlfriend, they got married shortly before he passed away. So she was entitled to his estate. They were in California, I believe. I'm not familiar with their laws, but since he did not have a will, his wife petitioned the court when they opened the probate process, requesting to be appointed as the personal representative. Now, if you think about the examples I just provided for Maryland and North Carolina, because his parents were still alive, in theory, she would get majority of the portion and, a certain portion of it, and then the remaining would be split between she and his parents. I think because in this situation, she had a good relationship with his parents, they agreed to split everything evenly. However, I think the estate was valued at like maybe 3 or 4 million, but because of the fees and taxes that had to be paid, it reduced the amount that they actually inherited by 1 million, at least 1 million. So they ended up splitting. Now, granted, they still each split over $1 million, more than I would say, no, that I have, and a lot of people have, but it took 2 years to get to that point. And so in addition to the amount of money that was spent to the court in taxes, they more likely than not had attorneys handling this. So they now have to pay whatever the attorney's fees are that have racked up over the last 2 years. So although it is still a large amount of money that they're walking away with, in whatever license, whatever rights he may have had in terms of intellectual property, it took 2 years to get it, and it's reduced by however much they had to pay out. And most, if not all of this could have been avoided if he'd had a plan in place, whether that have been a will or a trust. Another is Prince, or the artist formerly known as Prince. He died back in 2016, I believe. This was one that, was definitely sad that he passed, sad to hear about it, but I was very shocked to learn that he passed without a will, especially because throughout his life, he was very, very vocal about ownership, and he worked very hard to own his masters and own all of his material, and was very particular about, who could play his music, who could sample it, who could use it. And so to learn that he passed without a will was very shocking, because and that's me making assumptions, but I figured, hey, if you were so adamant about ownership and having control of your creativity or your creative process, that would have translated into creating a plan for what happened to that. So as you can imagine, Prince's estate was worth millions. But like I said, he died without a will. He did not have any children at the time of his death. He and his wife had been divorced for many years, so it was left to be split between his siblings. Now, with his, it wasn't just a matter of money. Like I mentioned, he owned his masters. And so there's also all of the ownership licensing rights for his music and all the intellectual property that he owed, it had to be determined, okay, who is entitled to this? Is it, were there different publishing companies? Of course, they tried to get a say in it, but with his, it took 6 years to settle the estate. One of his siblings passed away during that time frame, so then it was a matter of figuring out if they had any heirs. So it just, like I said, a much longer drawn out process and a lot more money and stress than needed, which could have been avoided. The third fictional character, but I think we all are familiar with Cinderella. This is one I would say I had a more recent revelation about, that I feel like a lot of Cinderella's issues with her stepmother and stepsisters could have been avoided if her dad had a will or had a trust or had made a plan. And I don't know how big estate planning was at that time, or if, I know he died unexpectedly, but either way, this is the situation where I mentioned before, where you're thinking about blended families. In this case, everything essentially went to the wife, and I'm sure it was his intention that his child be provided for, which technically she still was, because she was still, she was not homeless, she was fed, she was provided for, but had he, specified in his will or a trust that, hey, I allocate a specific amount of funds to my daughter, and I appoint this person as the trustee, to manage it and distribute it, and this is the standard of care that I want my daughter to have, then that would have tied his wife's hands in terms of what she could or could not do, or at least limited it. Of course, once we're gone, we can't control what other people do, but while we're alive, we have the ability to write out and be specific about what we want to happen once we pass. Specific, and it's important in general, but definitely if you have children, or you have minor children, or you have anyone in your family that you are responsible for who has a disability or special needs. So like I said, these are 3 examples of 3 very well-known people that unfortunately did not have a plan in place when they passed away, and it led to a lot of stress and additional grief in their absence. So, talking about making a plan. So how do we avoid some of the stress that these people have dealt with? And so that would be, one option is making a will. And so what is a will? A will is a written legal document that addresses what you want to happen when you die. You can specify who will care for your minor children, what you want to happen to your property or who you want to own it, various miscellaneous belongings, what you want to be done with your money, any money that you may have. When I say miscellaneous belongings, that could be if you have a rare stamp collection, if you have a lot of vinyl CDs, if it's cookware, clothing, jewelry, all of the things that you have, you can specify what you want done with them. If you want to leave something to charity, if you want, where you want to be buried, how you want to be buried, all of those things can be included in your will. Now, requirements to create a will, a valid will, you have to be at least 18 years old and have the capacity to enter into a contract. And this is mental capacity. And most states require that it be signed by the testator or person creating the will, testator or testatrix, depending on where you are. But that is essentially the person creating the will. So you have to sign it, and it has to be signed by 2 witnesses. Most states do not require that the will be notarized. Some people do that just as an extra measure. And some states will, if the will is notarized, then it's considered what's called self-actualizing, in the sense of it's valid and it's verified. One thing about the 2 witnesses that I like to point out, it's not necessarily a requirement in most cases, but I strongly encourage people to have the witnesses be someone who is uninterested. The will needs to be, I did see just one question come in, and I'll address this too right now. So the question is, does the will have to be signed by a beneficiary? And it does not. And actually, what I would suggest is you do not want it signed. You do not want a beneficiary to witness it, because the reason behind that is, if after you pass, if for some reason someone is who has been left out of the will, or even someone who's in it but feels as though they should have gotten more, they might want to challenge the will. And if one of the people who are a beneficiary of the will, or someone who stands to inherit something from the will, if they have signed as a witness, then that kind of gives someone a little more standing to challenge it, to say that it may not have been valid, or this person may have had undue influence on the person creating the will. So like I said, recommendation is to have 2 uninterested people sign as a witness. One of the things that I do to help avoid that is, when I am doing a will signing, I provide witnesses. So that way they are objective third parties. That way, hopefully no one challenges it, but if there ever is an issue or a challenge, you can say, these people had nothing to do with the creation of the will. So the other component, and I guess when we talk about estate planning, like I said, the pillars of estate planning, you're going to have the portion that applies to the life, to while you are living, and some call those ancillary documents. That would be the advanced medical directive, the power of attorney. Those are ones that's components of it. So you can have a will-based plan where the will is the primary instrument that provides all the instructions for what you want to happen when you pass, or you can do a trust-based plan. I always say, growing up, when I heard trust or a trust fund, baby, I thought it was rich white people or just very wealthy people, and that was not something that applied to me. But thankfully, I have learned otherwise. And a trust is essentially, it is a legal relationship. Essentially, it's a contract that's created, but it's essentially an agreement to put property in, I like to say, kind of a bucket. So I'm taking my house, and instead of owning it myself, I'm creating this entity or this pocket over here to own my house separate from myself. So like I said, it is a legal relationship by which one person or entity holds title to property for the benefit of another person or entity. Now when we talk about trust, there's kind of two ways of creating them. It can be what's called an inter vivos or vivos, which is a living trust, which means I make it while I'm alive, or a testamentary trust. And that means it's created, you use a will, and in your will, you include language and instructions to create a trust, and the trust will be created after you pass away. So with a living trust, it could be a revocable living trust. And that's one where if I create it today, but let's say in 5-6 years, things change, I don't want it anymore, I can revoke it. As long as I'm alive, I can start it, I can open it, create it, close it, or cancel it. It's up to me because it's revocable. An irrevocable living trust is one that it cannot be revoked until you have passed away. And like I said, with the testamentary one, it does not get created until after you die. So some of the reasons or uses of a trust that a lot of people think about is to avoid probate. But the bigger one is asset protection and disability planning, as well as time dispositions. So going back to even thinking about the situation with Terri Schiavo, let's say she didn't have the advanced medical directive in place, but there was a trust. And in that trust document, she specified, in the event of me being disabled temporarily or permanently, this is who I want to take care of me, this is what I want done, and this is how it should be funded. So you can make plans for that, especially, like I said, with respect to disability planning, even for yourself or for children or loved ones. If you've ever heard the show Inventing Anna comes to mind, where she just kept talking about, when I get access to my trust, or I need my dad to, release money from my trust, he's holding it up. People create trust, and you can put provisions in the trust that says, okay, once you reach the age of 30, then you can have a percentage of your trust, or you can't have any of it until you graduate from college. If anyone ever watched the show Power, in the last scene or the last season, when Ghost died, and he had created a trust, and one of the provisions for his son was that you have access to X number of money, but you can't get it until you graduate college with a specific GPA. So it might seem crazy to hear, but that's one of the things that you have the right, the privilege to do, to create, because it's your money, or it's your property, it's your assets. You can decide how you want it used, how you want it distributed. So like I said, this works for while you are alive. If you do a revocable living trust, you're not giving up control or complete control or access to your assets, you're just separating them from yourself. And so that's kind of goes to the asset protection piece of if you were to be subject to creditors, and let's say you own your home, but you have transferred ownership of the home to your trust, then legally you do not have. So if I'm using myself as an example, if I take my house and I do a deed transfer to where the title is in, deed is held by my trust, Latavia no longer owns a house. So if I get into a situation and I have creditors coming after me, my assets no longer include property. They have to go after whatever else I have. So that's another function of it. So as I mentioned in the beginning, there are, tax concerns related to estate planning. Most, I would say the tax, kind of inheritance tax or tax issues do not apply to the vast majority of people, because the gift tax is at a 40% rate. So it's essentially top rate of 40%. So if your estate exceeds 11, and here it says it exceeds 11 million, then yes, that tax rate applies to you. But if your estate is below that, so like here in Maryland, the rate is 16%, but there's an exemption of the first 5 million. So if your estate is not 5 million, then you don't have to worry about that. But one of the things that are required when anyone passes is you have to do an income tax return. So IRS is here and is going to try to make sure they get theirs when we are alive and when we're dead. So if you are the person who has been named as the personal representative, or even if you are the trustee of a trust of a person who has died, you want to make sure that you file that final income tax return and settle any outstanding taxes that are due. So like I said, these are the various tax rates. What I encourage you to do, regardless, is have a conversation with whether it be the person who does your taxes or a CPA, just to make sure that you are aware of what, like I said, what tax rates apply to you. And these are also things to take into consideration when trying to make the decision of whether or not a will or a trust is best for you. If you don't necessarily have a lot of, if your assets are not that high in value, then a trust may not be necessary, because you're not necessarily going to face a lot of tax penalties. But if you have or anticipate having a larger estate, then that is something, like I said, you want to consider. So we've talked about what estate planning is, why we need it, the life documents, as well as the documents for after we pass. So I know that this is not the sexiest topic, and it's not something that we all enjoy talking about, and some avoid like a plague, but it starts with the conversation. I always like to say it starts with the conversation with yourself. No, that does not make you loopy. It just makes you aware. But like I said, the best way to have the conversation or approach having the conversation is to rip the Band-Aid off, because as I mentioned before, we are all going to die at some point. And so death is a part of life. So we're trying to have the conversation. How do we prepare? These are some tips that I encourage you, in terms of ways to approach it. Like I said, starting with yourself, think about what are your goals? What am I trying to accomplish? What do I want to happen in terms of what I want control over, or how I want things to be handled while I'm still alive, whether that's while I am of sound mind, in the event that something happens, and then when I die, what is it that I want to happen? How do I want this to look? And so that once you identify those goals, that helps kind of, guide the conversation. Think about your loved ones. Do you have a spouse? Are your parents still living? Do you have children? Are you responsible for any adults who maybe have special needs. We all hope that we, pass before our children, but what happens if you were to pass and your children were still minors? Who do you want to be the person to take care of them? How are you going to make sure that they are taken care of? If it's you're planning for college, things like that. Like I said, children or those with special needs, think about the assets that you have, whether it be you own property, bank accounts. If you're an investor, you invest. So what's in the investment accounts? If you have retirement accounts, if you have life insurance, think about all of the assets that you have, make a list. Whether or not you want to be buried or cremated, if you want to donate your body to science, or you want to be an organ donor, if you want to make charitable contributions. For example, I believe it's Warren Buffett and Bill Gates have said that they plan to leave a majority of their estate to charity, that they're not going to leave everything to their children, because I feel as though their children have had plenty of opportunity to access those things while they're alive. And then, like I said, insurance policies. So think about all of those things. If you are single, think about it in the sense of, okay, what do I have? Who would I want to be the person making decisions for me if I am unable to do so for myself, or when I pass? If you're married, have the conversation with your spouse. Or like I said, if you are helping to take care of your parents, or you are responsible for the well-being of someone else, think about all of those things. And like I said, either having that conversation with your loved ones, because it's one thing to have a plan, and I have the plan here, or I've written it down and I've got all these detailed instructions. But if nobody knows about my plan or knows how to find it, it's almost like I did not have a plan. So make sure that you are having this conversation with the people, specifically, if you're going to list somebody as your personal representative or executor of your estate, make sure they know this before you die. Or it's the same with a power of attorney or healthcare agent. Make sure that they know that they're the person. And even though you're writing it down, have a conversation with them about what it is that you want. So we're going to fast forward a bit. We're just going to say that you have a plan. You've made a plan. It's in all the people who need to know about it, know about it. So these are some things that happen kind of regardless of what the plan says when a person dies. So you're going to want to contact the funeral home, whether they want to be buried or cremated. That's something that's going to need to be coordinated. So the funeral home, they pick up the body, they provide a death certificate, or they submit the death certificate application to the respective state or county's vital record office. Then a death certificate is going to be issued. Now, the death certificate is going to be key to carrying out just about everything when it comes to administering the estate. So whether there is a will, a trust, or none of the above, there is going to be some level of administering of the estate. There's going to be a process. Like I said, if the person had life insurance, you're going to want to contact the company and notify them of the death. There are some policies that have a provision that they will pay funeral costs. Then the funeral home will submit a claim to the insurance company, and they will essentially determine whoever's listed as a beneficiary, that is who the proceeds or remaining proceeds will be distributed to. Same with if you have a pension, a retirement plan, or Social Security Administration, you want to contact the administrator. Then these agencies, they're only going to speak with the beneficiary. So with all of these, with the life insurance or various pension retirement plans, you will need to provide a copy of the death certificate. So when you order when the death certificate issued, it's best to go ahead and order or buy at least 10 copies, so that way you have them, so that way you don't have to keep going back and ordering them as needed. You just have them when they're requested. So probate, I have mentioned this a few times, and you may have heard this before, and it's this kind of Probate, I've been more and more, I'm hearing this whole thing of avoid probate. But what is probate? So probate, it's literally the process of distributing the assets when a person dies. So like I said, if someone dies without a will or even with a will, you're going to need to go through the probate process. And even with the trust, there are components of a probate process. It just becomes a matter of if it is going to be public and going through the courts, or if it will be private. So every county and every state has a register of wills or deeds office that manages this process. If there is no will, then it's certainly required well, I should clarify, with a will or without a will, the probate process is required if there are any assets that pass to that person by will or intestate succession. So essentially, if it's not something that passes automatically, regardless of a will, it's got to go through the probate process. So it could be if there is a car that was titled in the deceased person's name and it's going to their spouse or to their child, you have to go through the probate process to be able to transfer title to the next person. Like I said, you're going to need to provide a death certificate and the will. When you go to open up, they call it opening the estate or opening probate. There is a fee, and that varies based on the state or county that you're in. The personal representative or executor, depending on the state, they're called different things, but they are the person that's responsible for locating, accounting for, and distributing assets. So if you have been named the personal representative of someone's estate, you are responsible, but that does not mean that you literally have to be the one to do everything. You can hire an attorney or hire a CPA, a financial person, to kind of guide you through that process. And most states allow for the personal representative to be compensated for their efforts to, up to a certain amount. And so with the probate process, what it does is it cuts off creditor claims. So one thing that I've gotten the question a few times, and that I think people are often concerned about is, oh, okay, this person died, they owed X amount of money, and now these people are coming. So one of the things as a part of the process is you're going to essentially give notice to all creditors that, hey, this person died. So if you have a claim, you need to submit it to us within a certain amount of time so it can be determined if this money is owed or not. And so when you go through the probate process, it cuts off the claims or the time frame for creditors' claims if they're not given by the earlier of 6 months. Essentially the earlier of 6 months after the person passes or 2 months after the personal representative publishes the notice of appointment. So as unwanted as the probate process can be, it can also be beneficial because it shortens that window and reduces the likelihood that a year or 5 years later, some creditor calls you out the blue claiming that your mom or your brother owed them money and they're now trying to collect on that claim because, hey, so sorry for you, that window's closed. So, like I said, probate is a part of estate administration. There are some aspects of it that are inevitable, but to reduce the time and the costs associated with it, there are different tools that people use to avoid probate. One of those main ones being creating a trust, a revocable living trust, because with that, in most situations, and I'll use myself as an example, if I create a trust, I'm the trustee of that trust. And I include language that, okay, when I pass, I'm appointing my sister to be the trustee of my trust. And she is now responsible for it and distributing whatever assets that I say I want distributed. And no courts are involved. It's a private process. You just a matter now, if there are, let's say, for example, that I have put title of my house into the trust, and I've said that I want this house to go to my child or to whomever, then it would still be up to the trustee to coordinate with whomever it was needed to execute a deed transfer, or to, if I say I want the house to remain in the trust, then it remains in the trust nothing needs to be done. Another option is life insurance. If you don't have it, I recommend you get it because it's just beneficial, and it's a tool that helps. That could be another tool in terms of leaving some, to create some transfer of wealth upon your death, but that's another conversation. So with life insurance, you designate beneficiaries. So this is one of those things that that probate is not required. So whether you have a will, a trust, or not, whoever you designate as the beneficiary on your life insurance policy, that is who is going to get the proceeds from your life insurance policy. Another tool is with your bank accounts, just about every bank has some version of a transfer on death or payable on death that you can add to your bank account. And what this does is when you pass away, if you essentially, it creates a beneficiary or treats it like you've added a beneficiary to the bank account. So when you, let's say I'm using myself again, if I pass away and I have listed my sister as the person who's transferred the payable on death, when I pass, she takes a copy of my death certificate, provides that to the bank, and they can, in her identification, they see that her name is, she is the person, and then they will release the funds to her. This helps to avoid probate. This also comes in handy if, let's say, I have the money set aside to pay for my funeral costs or any, kind of monthly expenses. The money is there. If you do not have this set up, then you have to wait until you go through the probate process, and then the court essentially grants what they call letters of administration. You then have to take that to the bank for them to release the funds. So depending on the person's state of mind, or the various the time frame of the process, it could be months, it could be a year before you have access to that money. So this is something that you can do so that way you have access right away to use as needed. Another option is a transfer on death deed. I put an asterisk here because not all states recognize transfer on death deeds, but what it is essentially you create, similar to how you put a transfer on death on your bank account, you can execute a transfer on death deed. And what it does is when you pass away, instead of having to go through the probate process, it automatically, you still have to, get the deed updated, but it designates who you want the property to go to. And so that's one less thing that will have to go through the probate process. So I've touched on some of these already, but these are some what we call I refer to them as forgotten assets, because sometimes people forget either to put them in the will, or they forget that even if they put something in their will, it does not apply. So any property you transfer to a living trust, it is going to be in that trust. As I mentioned, life insurance proceeds, because whoever you list as your beneficiary, that is who the life insurance company is going to give the money to. So an example, I had a client who wanted to include language in their will that the money from their life insurance policy would be used to pay for their funeral. And what I had to explain is that's great. And if you've had a conversation with the person, wonderful. And we hope that they will honor your wish. But the reality is, one, if you have not listed that person as the beneficiary on the policy, then they don't have the money and they can't do anything. But also, if they decide that once they get that money, I don't want to use it for that, they don't have to, because once it is issued to them, it is legally theirs. So funds in an IRA, a 401k, or any other retirement account, once again, you've designated a beneficiary. So that's who the money will go to. If there's any securities, like I said, in transfer on death or payable on death accounts, or property you own in joint tenancy or tenancy by the entirety with someone else. All of these things are going to pass based on what essentially the contract or the instrument that created them says is going to happen. So just the thing about joint tenancy or tenancy by the entirety, that refers to property So if you own, and this is most common with spouses. So if you own the property as tenants by the entirety or joint tenancy with the right of survivorship, what that means is when one spouse passes away, their interest automatically transfers to the other and nothing needs to be done. So another example, and this is the Queen of Soul, Miss Aretha Franklin, another person, like I would say, it was sad when she passed away, but also shocking and disappointing to learn that she did not have a will or any, trust or anything in place. So she died in August of 2018. And the reason I have this example here is because I mentioned earlier about a valid will or making sure people know about a will. So when she died, there was no known wills, like nobody knew of any will. In the years since she's passed, there have been 4 different wills that have surfaced. All are incomplete, and so all have been determined to be invalid. So her estate has been treated as though she did not have a will. The other challenge with this is she also owed taxes at the time of her death. There were several years of back taxes that had not been paid. And so since 2018, her sons have been fighting, via their lawyers, have been fighting in court to determine how much is actually owed to the IRS. It took them until, I want to say it was 2021 to actually get to a settlement amount with the IRS, which was over $4 million that was owed in back taxes. So from 2018 to 2021, before that amount was settled, her sons did not have access to any of that money or any of the funds. So any of their inheritance, they did not have access to, because the IRS is going to make sure that they get their money even after you die. In addition to that, one of her sons has special needs, but there were no instructions left or provisions made for his care. And so there's someone who's, representing him. And then her other 3 sons are all fighting essentially to say who should get what, how much each person should get. There's also publishing companies that have a stake because I don't believe she owned all of her masters or all of her material. So once again, and I checked just last night, there are still aspects of her estate that still have not been settled because it took so long just to get the IRS piece settled in terms of figuring out what was the estate valued at, and then determining how much taxes were owed, setting up a payment plan for the IRS, and then now it's a matter of determining how much each son gets and how much publishing companies get. So, like I said, I don't have Aretha Franklin's wealth. A lot of us don't, or any of the others that I talked about. But I would say that the cautionary tale of it all is, even with all of those assets, there was so much money and so much time spent. But if we take the time to make a plan, we can avoid that. Because like I said, if you're already starting with less, and then you end up having to give the IRS or the state or attorneys 30, 40% of that reduces the inheritance amount drastically. So just a few things to remember, kind of summarizing all that we've covered in this session is, like I said, you want to make sure that you're updating beneficiaries after major life decisions. Another cautionary tale is a situation of if you have been married and divorced and you remarry, make sure that you have removed your former spouse's name from any policies, anything where you had them listed as a beneficiary, because if you do not, when you pass, that money is going to the former spouse, regardless of the fact that you wanted it to go to your current spouse or you wanted it to go to your children. It's a good practice to check your documents every few years. One of the things that I do is I provide a 3-year review of any plans that I create, just to kind of check in. Hey, what your goals were 3 years ago, are those still your goals now? Have there been any changes? I would say treat it similar to if you work for a company and open enrollment. They say you can change it after major life changes. So if you have children, it's time to update it. If a child graduates, they're no longer a minor, let's update it. If you move, you acquire more property, you start a business. So like I said, making sure that you update and or change the name on the title or property. Like I said, making sure people know about your plan and where to locate the documents. Most states or counties have the option that you can register your will with the county. So then the county has a copy of it or the original. That's an option. We do a lot of things digitally now and social media. So making sure a trusted person knows what you want to be done with your social media accounts, and people have access to your various accounts, what your password, your login information is. If you have pets, what do you want? Who should have your pet? Who should care for your pet? If you have a safe, who has the key? If there's a safety deposit box, how to access it. If there are any reoccurring accounts, a lot of us we have streaming services. Do you want to still be the person paying for those when you die? So essentially making sure that one, you've created a plan and you've crossed your T's, dotted your I's, and that someone knows where these things are. Like I said, what are your burial wishes? If there's anyone listening who was in the military and you want to be buried in state, that is something that in most situations needs to be coordinated ahead of time. It's not automatic. What do you want included in your obituary? You can get as detailed of, what outfit you want to be buried in, where you want to be buried, how. Do you even want a funeral? Do you want a memorial service? Just all of those things you get to decide. I had one friend, she described it as, this is going to be, my funeral is my one last party, and I get to decide how it's going to be. So like I said, remember, if your wishes are not documented, they are not legally enforceable. And so just overall goals of estate planning are to reduce stress and anxiety while you're alive, because you have things sorted out. And then it's to reduce stress and anxiety for your loved ones after your death. And you want to minimize the impact of professional fees, court costs, and taxes, and to make sure that the estate administration process is as efficient as possible. So that is all I have at this point. I did see that there were a few questions. I'm going to go back to address the questions that came up during the session. If you have any additional questions at this time, please, you can put them in the Q&A or the chat. So the first question that came up was whether or not a trust could pay for college while requiring they graduate to receive funds. And the answer is yes. As I mentioned, you can include specific provisions in terms of how you want funds dispersed. So you could state that, hey, I have put X amount of money in this investment account, and the money here is to be used to pay for my child's college. And then let's say there's a money in a separate account that has been growing, but they cannot have direct access to funds until they graduate or until a certain qualifying event. Another question is, if you have a POA, do you still need an advanced medical directive? I would say yes, because they cover two different things. The advanced medical directive speaks specifically to health matters and goes into more detail there, whereas the POA would, potentially give them access to, if they needed to pay a bill, they could contact the hospital or medical provider to get access to it and make payments in some decisions, but it's still going to be limited. So it's good to have both. Okay, are there any other questions? Oh, wait, I'm sorry. I got one more. Are there provisions for estate planning documents to be done digitally without having to sign physical documents? During the height of the pandemic, there were some provisions in place. There are a few states that have started allowing for digital signing essentially, but not many. So unfortunately, yes, right now, a wet ink is still required, but as we have adapted to this new largely virtual world, there are ways around it. So I know some people, what they do is they, work with the client, we prepare everything, and then send it to you with instructions on where to sign and how to sign, so that you don't necessarily have to, meet in person, because that is something that is still a concern for people. It can be a matter of, like I said, either sending it, scheduling a meeting, sending one to one person, because for some, especially if it's one that requires a notary, there are still, I know specifically in Maryland, they have, it is allowed for digital notary. It's just the notary has to have a specific certification and, follow certain procedures. So I think it's coming. It will probably be in the near future where we can do things completely digital without a wet ink. But for now, I would say, erring on the side of caution, it is better to have a wet ink signature. Okay. If there are no other questions, we'll say that concludes the session. So I do want to thank you all. Oh, wait. Okay. I do want to thank you all for participating. And once again, like I said, congratulations and thank you for being proactive and making the decision to, like I said, participate in this conversation. This will be the first of a few in terms of a series of just, I want to, like I said, continue the conversation, because estate planning can become very nuanced. There's a lot of different parts or components. So like I said, the goal today was to provide an overview and to get your wheels turning. And hopefully, if you have not already created a plan, that you will start working on one and having the conversation with your loved ones and friends. Here's just a list of the other services that my firm provides, whether it be business formation, trademarks, copyright, as well as, like I said, a legacy planning. For those of you who have attended, you will receive an email after this session, and you get a 20% discount on a legacy plan consultation. So you will receive an email with a link to schedule, or link to use to schedule that. But I want to thank you all again for participating, and I do hope that this was helpful. If you have additional questions or further questions, like I said, please feel free to contact me either utilizing the website, or my email is info. You can contact me via email at info@lalegalsolutions.com. So thank you all again, and I do hope that you have a great evening.